Welcome to Audit the Audit, where we sort out the who and what, and the right and wrong of police interactions. This episode covers the knock and talk doctrine, profanity and community caretaking, and is brought to us by Sarah Hawkins' channel. Be sure to check out the description and give them the credit that they deserve. On May 10, 2020, the Suisun City Police Department received a call from North Bay Medical Center about an individual who had potentially ingested nail polish remover. Officers Tiffany Canoma and Cody Marler responded to the call and were dispatched to the Suisun City, California home of military veteran Sergeant Sarah Hawkins. Yeah, sorry. Hello, hey. I don't know who that is. You know who that is. No, who's your girlfriend or your baby mama? Lady right here. First of all, that's my wife, Marvin. Okay, Marvin. Okay, and who, Connor? Who are y'all looking for? One of two. Can you go with the mother's name? What's the problem? So we're here on a welfare check. We have to make sure she's okay. Why? Because we received a call from North Bay for the incident that occurred earlier. What incident? What's your last name, Kelly? Look right there. Supposed to be an investigator if y'all investigate. Right there, 9 years, U.S. Army. Now what's the problem? Okay, what's your first name? I don't have to identify myself to you, do I? Am I under investigation? You want to tell me what's going on? One of two. Can you confirm the address? Can you come out here? No, she can't come out there. Y'all need to tell me what's going on. This is my house, we told you, Kobe. They're advising that this is not the right address. A welfare check for what? No. I got it, got it, ma'am. Y'all violating my rights right now. Actually, we're not, dude. Yes, you are. Because you're not telling me. I don't know who that is. I just said it to you. Listen to me, dude. We're not violating your rights. You are how? Because you, which right you? Which civil right are we violating? Why are you raising your voice? We're not violating anything. Okay, so we are here on a welfare check. I can go inside my house. We are here on a welfare check. Sergeant Hawkins asserts that the police are violating his rights, although he does not explain how, and the officers argue that they are not violating any rights by standing on his porch. The area immediately surrounding an individual's home, including the front porch, is known as the curtilage, and Supreme Court precedent protects curtilage as part of the home itself for Fourth Amendment purposes. In the 2013 case of Florida versus Jardine, the Supreme Court noted that, quote, but when it comes to the Fourth Amendment, the home is first among equals. The amendment's very core stands the right of a man to retreat into his own home, and there be free from unreasonable governmental intrusion. This right would be of little practical value if the state's agents could stand in a home's porch or side garden and troll for evidence with impunity. The right to retreat would be significantly diminished if the police could enter a man's property to observe his repose from just outside the front window. Nonetheless, under the so-called knock and talk doctrine, officers generally have the authority to enter a home's curtilage, to knock on the door and ask questions without a warrant. The court explained in the Jardines case that, quote, the knocker on the front door is treated as an invitation or license to attempt an entry. This implicit license typically permits the visitor to approach the home by the front path, knock promptly, wait briefly to be received, and then absent invitation to linger longer leave. Thus, a police officer not armed with a warrant may approach a home and knock, precisely because that is no more than any private citizen might do. However, this doctrine does not authorize officers to bypass the warrant requirement of the Fourth Amendment, to conduct searches, or engage in activity that exceeds the scope of accepted social norms. As the court detailed in the Jardines case, quote, to find a visitor knocking on the door is routine, even if sometimes unwelcome. To spot that same visitor exploring the front path with a metal detector, or marching his bloodhound into the garden, before saying hello and asking permission would inspire most of us to, well, call the police. The scope of a license is limited not only to a particular area, but also to a specific purpose. Applying this standard, lower courts have found certain police behaviors to exceed the scope of the implied license. To knock at an individual's door without a warrant. For instance, in the 2022 case of Cupp versus Smith, the Northern District of California found that an officer exceeded the scope of the implied license to knock when he approached the garage area, entered the garage door, spoke with the homeowner's worker, walked through the carport, and took multiple photographs of the garage and surrounding area. Similarly, the Florida First District Court of Appeals held, in the 2013 case of Powell versus State, that an unconstitutional search occurred when police officers stepped off the front step of a mobile home and looked into a window they could not see through. From the front step, the court explained that, quote, even when governmental agents are engaging in otherwise lawful knock and talks, they can exceed the scope of a reasonable visit to a front porch through physical actions that encroach into areas in which the resident has a reasonable expectation of privacy. But the decision also noted that, quote, under certain circumstances, implicit permission may exist to look through an uncurtained window while standing on a front porch momentarily to see whether the resident is approaching the door, assuming no unreasonable means or devices are used in this situation. While a court would almost certainly conclude that the officers did not violate Sergeant Hawkins's rights by knocking on the door to ask questions, it is less clear how a court would view the officers walking over to look in and knock on the front window. Under the walk and talk doctrine, however, as we will discuss later in this episode, a court would likely determine that this was not a violation of Sergeant Hawkins's Fourth Amendment rights. Under the exigent circumstances doctrine, I don't know what that means. Stop talking. Let me talk. I don't have to stop talking, child, for that, right, okay? That's right. Why is he right? I don't like him. He's raising his voice at me right now, or nail polish, okay? Okay, so come here, your baby check right there, okay? I'm gonna talk to you first of all. You came to my house and say, is that my girlfriend or my baby mama? That's my wife, okay? That's disrespectful starting off, all right, sir? So that was disrespectful starting off. And then he's raising his voice at me, okay? I understand, so now I can raise my voice, right? No, you can eat it. What's his problem, okay? Okay, no. I need your badge number. I'm sorry, that's fine. I'll give you my badge number, but so the reason we're here. It's now you're telling me the reason after you told me to eat it, sir. So you told me to eat, right? That I messed up, I apologize. Now that you're on film, you messed up, so you haven't violated any of my rights. No, the first thing you said to me coming here was, is that my baby mama or my girlfriend, sir? Then he started raising his voice at me. Pause, I need your name and your badge number. Officer Connor, 1 week of 7. Thank you. I need your name and your badge number. And she's at my window. I told you not to go to my window. Close the blinds. Do you have a 14-year-old son? Close the blinds. Hold on, sir. Sir, close the blinds. Sir, do you have a 14-year-old son? Close the blinds. Close the blinds. I'm not going in the house. Close the blinds, okay, ma'am? Are your children okay, okay? Do they look okay, guy? He's asking if my children are okay. Who the fuck is that, okay? We're talking about we're gonna leave now. Give me why, 'cause I gotta eat. That's why you leaving now. We're gonna leave now. I don't know who the 14-year-old is. My family was here all day. We had a good day. You're here telling me to eat a kid is... I don't know who the 14-year-old is, okay? I told you 9 years in the military. Okay, you told me to eat, so okay. Thank you for telling me to eat, please. After I served you for 9 years, How about you get the fuck off my property, Marla? I don't give a fuck. You are probably a piece if you serve and you telling people to eat. You probably was a piece. All right, you can get out of here. That's what you can do, Marler. You babe, get in the house, okay? Let me explain, 'cause we may have... You said you told me. Can I explain to you? After Officer Marler directs a vulgar insult towards Sergeant Hawkins, Sergeant Hawkins becomes understandably enraged and begins to direct profanities back at Officer Marler. While Officer Marler's conduct was not criminal, his behavior was in clear violation of Suisun City Police Department Policy 323. Which details standards of conduct for officers in the department. Lists discourteous, disrespectful, or discriminatory treatment of any member of the public, use of obscene, indecent, profane, or derogatory language while on duty or in uniform, and any other conduct which any member knows or reasonably should know is unbecoming a member of this department, or tends to reflect unfavorably upon this department or its members as potential causes for disciplinary action. Should also be noted that, as we have discussed many times on ATA, Sergeant Hawkins was well within his rights to express his displeasure with Officer Marler's conduct through the use of profanities and insults. And as the Supreme Court explained in the 1987 case of City of Houston versus Hill, quote, the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. Did you go to North Bay today? What is that? Get in the house? What are y'all talking about? Nobody knows what y'all are talking about. Well, you're not letting me explain. You never explain. You started asking questions. You said, is that my girlfriend or my baby mama? Okay, I apologize for that. Okay, I'm here to clarify. So it may have been a miscommunication between North Bay and our dispatch, so we got a call that we need to... Okay, a 3-year-old was brought into the hospital because she ingested nail polish remover, okay? We don't know anything about any of that. And that is absolutely fine. So this just got a little out of hand. But you don't come to somebody's house and say, if that's your baby, I'm your girlfriend, right? And I completely understand You're supposed to be professional. I'm trying my best to be professional. And if you're doing fine, but that guy, I don't know what side of the bed he woke up on. Put yourself in my shoes, 2 cops knock on your door, boom. Dun-dun. I'm in there having a good time with my wife. Okay, of 5 years.
They are who I have now scared.
Okay, you probably scared them, they don't know. You knocking on my window, all right, you. After Officer Kanama asks Officer Marler to step away, she explains to Sergeant Hawkins that they were sent to his home on a welfare check regarding a potential medical emergency and that they must have been dispatched to the wrong address. A welfare check occurs when the police respond to a call or other request to check on an individual's well-being or safety. Welfare checks are not criminal investigations, but they are related to police officers' so-called community caretaking function, which the Supreme Court defined in the 1976 case of Katie versus Dombrowski as police duties that are, quote, totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. Although the Katie decision involved a vehicle and did not apply to homes after it was published, many lower courts interpreted the holding as creating a quote-unquote community caretaking exception to the warrant requirement that allowed officers to enter homes without a warrant for a non-investigatory purpose, such as to prevent a suicide or to conduct a welfare check on an older individual who's been out of contact. However, the Supreme Court clarified in the 2021 case of Caniglia versus Strom that there is no standalone community caretaking exception to the warrant requirement for homes, that officers cannot enter a home or the surrounding curtilage while performing a community caretaking function unless an exception to the warrant requirement applies. Still, many warrantless entries that had previously been justified under the community caretaking doctrine could still be justified under the exigent circumstances doctrine, which, as Justice Kavanaugh explained in his concurring opinion, quote, allows officers to enter a home without a warrant in certain situations, including to fight a fire and investigate its cause, to prevent the imminent destruction of evidence, to engage in hot pursuit of a fleeing felon, or prevent a suspect's escape, to address a threat to the safety of law enforcement officers or the general public, to render emergency assistance to an injured occupant, or to protect an occupant who is threatened with serious injury. Here, because the officers were responding to a call regarding a potential medical emergency, it is likely that a court would find that the exigent circumstances doctrine applied, and that the officers could look in the window or even enter the home if no one answered the door without violating the Fourth Amendment. So y'all want me to quote what statute you guys are violating? I'm not one of those people, but I'm pretty sure I can go on Google and see if we have every right to be here to check on somebody, and you have the right to Google us and make sure you have the right to be here and check on somebody. Yes, did I have to come out my door? You did not. We needed to come exactly on the female, okay? I'm leaving now, sir. Okay. Have a good night, sir. Shortly after Officer Kanoma left Sergeant Hawkins' home, Officer Marler returned, knocked on the door, and apologized for his prior behavior. However, Sergeant Hawkins was not appeased, and he posted the footage he recorded of the interaction on his YouTube channel. In response to public outcry, the department issued a public statement on May 13, 2020 that read, over the weekend, one of our Swedish city police officers was involved in an unfortunate interaction with a resident while responding to a call for service. During that incident, the officer involved used language that was not appropriate and not within the standards of the Swedish City Police Department, City of Sweden City, and the Sweden City Police Department. Want to assure our residents that this type of behavior is not tolerated by any measure. The statement also quoted Chief Aaron Roth as saying, quote, this is an unfortunate incident that we will use as a learning opportunity to do better as we continue to work with our community to make Sweden City a better place for everyone. On behalf of the Sweden City Police Department, I would like to publicly apologize to the residents involved in this incident and to the entire community. As a result of the incident, Officer Marler was released from his position at the department, but it's unclear whether he was terminated or if he was allowed to resign overall. Officer Marler gets an F for making disrespectful assumptions about Sergeant Hawkins's relationship with his wife, using profane and vulgar language towards a citizen, and displaying a complete lack of professionalism throughout the encounter. While Officer Marler did eventually apologize, his conduct completely derailed the interaction from the beginning and prevented the mistaken address from being quickly identified. Instead of working to locate the correct address for the individual who may have ingested nail polish remover, the officers were required to spend valuable time resolving Sergeant Hawkins's well-warranted complaints in situations involving medical emergencies. This sort of delay could be fatal, and it easily could have been avoided here if Officer Marler had simply behaved professionally. Officer Kanoma gets a B because, although there is certainly room for improvement in the way she and Officer Marler initiated this interaction, She maintained a professional demeanor throughout the interaction, attempted to de-escalate the situation, and remained calm, while both Officer Marler and Sergeant Hawkins lost their tempers. That being said, it certainly would have been helpful if Officer Konoma had explained the reason they were knocking as soon as Sergeant Hawkins opened the door, instead of immediately interrogating him, which made him defensive from the start. I hope that Officer Konoma learns from this encounter and improves her questioning techniques for future welfare checks and other similar situations. Sergeant Hawkins also gets a B, because while his angry response to Officer Marler's conduct escalated the situation and delayed the resolution of the interaction, his outrage was completely understandable, and his expressions of anger were protected by the First Amendment. As Sergeant Hawkins pointed out, he was not the one wearing a uniform, and I cannot fault him for making a stand against rude and insulting conduct from a police officer. This interaction illustrates the essential role officers play in setting the tone of an encounter. Had Officer Marler not made disrespectful statements from the beginning of the interaction, it likely would have been resolved quickly and without incident. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.